I'm taking our listeners and viewers live to the Supreme Court now to hear the side of the second respondent as they address the media.
A very good afternoon, ladies and gentlemen of the press, and a good afternoon to our fellow countrymen and women. After 3 months of trial in the highest court of this land, others refer to it as the apex court, the Supreme Court has today finally handed down the verdict of the court insofar as the 2013 election petition, 2020 election petition is concerned. It was a unanimous decision of all the 9 justices, 7 justices of the Supreme Court. I want to highlight a few of the things that the justices said for purposes of emphasis and general understanding. It was a 2-hour-long rendition, so I cannot do all, so I'll just highlight the salient points for brevity. Your Lordships started the delivery. Of course, the judgment of the court was read by none other than the Chief Justice of the Republic, Justice Kwesi Enin-Yeboah. They drew a distinction between the election petition of 2013 and that of 2020. Whilst the election petition of 2013 mounted a challenge to the validity of the election and called for the annulment of over 4 million votes due to overvoting, irregularities, lack of biometric verification, and absence of signature of presiding officers. The 2020 election petition was basically a challenge against the declaration of the results and not, emphasis, not the validity of the election. It was the declaration of the results that the petitioner sought to challenge. But the courts held that the declaration of the results is done in consonance with the data provided by first respondent. That is the total number of votes cast, the total number of valid votes cast, and the percentage of the total number of valid votes cast, and not the total number of votes cast. I want to stress the difference. It's a percentage of the total number of valid votes cast, and not the total number of votes cast. And by the data provided, the justices were left in no dispute that second respondent, His Excellency Nana Addo Dankwa Akufo-Addo, President of the Republic of Ghana, and still the Commander-in-Chief of the Ghana Armed Forces, had crossed the threshold of more than 50% plus of the total number of valid votes cast. In consonance or in tandem with Article 63(3) of the Constitution 1992. The court had a word or two to say about the testimony of the witnesses for the petitioner. And you heard the court rightly say that the petitioner was under no obligation to offer evidence himself by the presentation of a witness statement and mounting the witness box to testify. So was it that there was no compelling reason why first respondent and second respondent should have been made by all means to also adduce evidence in the trial. So there is parity of justice. Your Lordship said that the evidence of PW1, PW2, and PW3, that is Dr. Michael Pesa-White, and Mr. Johnson Asiedunkit, and Mr. Robert Joseph Metanunu. And I'll borrow the language of the court. It's not my language. The justices said their evidence was fanciful, and the least said about the evidence of these two persons, the better. That is not my language. That is the language of the Chief Justice of the Republic and of the court. Why did they say so? From the evidence adduced at the trial, their own evidence, they have certified 13 of the 16 regional collation results. And when they realized that the other 3 results were not favorable to their cause, they abandoned ship and left the National Collation Room of First Respondent, what hitherto was called the Strong Room. Your Lordship said they abdicated their duty and their evidence that they were tricked by First Respondent's chairperson to vacate the room before the declaration of results was unworthy of consideration, and that they should blame themselves for abandoning posts and not shift blame onto the doorstep of the First Respondent's chairperson. This is the language of the court. In fact, the court also said that they had 2 additional agents, so that even if they left, the 2 of them left, the 2 additional agents could have done what they should have done as agents in the collation room. PW2 and PW3 were under no obligation to leave the room, and the fact that they decided to leave they cannot complain of the declaration made in the error. Now, when it came to the star witness, Johnson Asiedu Nketia, this is what the court said. We did not come to court to challenge the figures declared by First Respondent, but that the figures declared contain errors, and in affecting the errors, the EC chairperson unilaterally declared the results contrary to Article 23 and 296 of the Constitution 1992. The Lordships posed a rhetorical question that what was the effect of this? And the answer was forthright. Your Lordship said the petitioner did not present any compelling evidence that there were breaches of discretion of Articles 23 and 296 of the Constitution 1992, and that errors by administrative tribunals are not matters for determination by the Supreme Court. That challenge lies squarely with the High Court. And that the discretionary power, if not exercised according to law, does not invalidate the valid votes cast at the election, and that those errors cannot amount to an invocation of the original jurisdiction of the Supreme Court. I'll shortly, in the course of my delivery, tell you some significant portions of the evidence which were quoted extensively by the justices to found the reasons for the judgment. Now, there were 5 issues that were settled between the parties for the consideration of the court. The first one was whether or not the petition disclosed any reasonable cause of action. And the others followed. It's whether or not the petitioner, the second respondent, obtained more than 50% plus of the total number of valid votes cast at the election, and whether or not the alleged vote padding and errors substantially affected or materially affected the outcome of the election. There were other ancillary reliefs of a breach of Article 23 and 296 of the Constitution 1992, a mandatory injunction placed on the EC, and also an injunction to restrain the President from holding himself out as President of the Republic, and for that matter, carrying out his duties as the first gentleman of the land. It is instructive to state that the courts decisively determined these issues in favor of the respondents. Indeed, to do fidelity to the Supreme Court and the truth, we cannot run away from the fact that the Supreme Court did not agree with the first and second respondents on the first issue, that the petition did not disclose any reasonable cause of action. But they were quick to also say that the petition will not be determined alone on that issue, and that the totality of the evidence will be called into play to ascertain whether or not the plaints by the petitioner, that none of them, that is the petitioner and second respondent, crossed more than the 50% threshold as mandated by Article 63(3) of the 1992 Constitution. Now, this is what the justices of the Supreme Court said to clarify and put to rest this thorny issue of the petition, and confirmed by the star witness, Asia Dunketia, was 30,121,111 votes. Now, the court also said that a party is always bound by his pleadings, and the only way the party can free itself from his pleadings is by way of an amendment. The admitted position of the petitioner, which was unraveled under cross-examination by second respondent's counsel, the Venerable Anthony Akoto Ampao. I bet most of you didn't know the first name. It was the Venerable Anthony Akoto Ampao. When the video clip was played in court, Now, second respondent garnered 6,730,413 votes. Petitioner garnered 6,214,899 votes. And the percentage of the valid votes, of the votes obtained against the total number of valid votes cast, came to 51.295% for second respondent, His Excellency Nana Addo Dankwa Akufo-Addo, and 47.366% for the petitioner John Dramani Mahama, meaning that second respondent had crossed more than the 50% plus of the total number of valid votes cast at the election, which was in contradistinction to what the petitioner had been saying all along. In the first place, before this petition was filed, the petitioner was bold to say that he had won the election. And the Deputy General Secretary of the NDC gave the petitioner a percentage of 50.15%. You heard it when the video clip was played. Indeed, Sami Jemfi, a communication officer of the NDC, hailed John Dramani Mahama as the president-elect. This position taken by the Supreme Court was not done in a vacuum. It was elicited from cross-examination of their star witness, PW1, by the Venerable Akoto Ampao. And you heard the rendition, which was lucidly given by the Supreme Court. Now, the Supreme Court also considered the Techiman South constituency presidential election results, which became a thorny issue in the declaration. It was the first respondent's chairperson alluded to the fact that even if the Techiman South, what's happening? Even if the Techiman South election results, presidential results, were added to the results at the time of the declaration, the second respondent still won the presidential election by more than 50% of the valid votes cast at the election. Now, the declaration of the results was tendered in evidence by the petitioner as Exhibit A. And Exhibit A clearly showed that the votes at the Techiman South constituency, and that without the Techiman South constituency election results, second respondent crossed the threshold and obtained more than 50% plus of the total number of valid votes cast. The addition of the Techiman South constituency results was played out in the manner following. The total number of registered voters in that constituency was 128,018, but 99,436 valid votes were cast at the election. And out of that number, the petitioner, John Dramani Mahama, received 52,034 of the valid votes cast, which put his total number of valid votes cast as 6,266,923 votes, which represented 46.379%. Second respondent, Nana Addo Dankwa Akufo-Addo, received 46,379 votes, moving his total number of valid votes cast to 6,776,792, which gave him a percentage of 51.295%, meaning that second respondent had crossed the threshold of 50% plus one. The Supreme Court justices also held that in fact and indeed the results of the Techiman South constituency presidential election was well known to the petitioner before the petition was filed. And for that matter, even an exclusion or inclusion of the Techiman South presidential results wouldn't have made any difference at all to the results as declared by the EC's chairperson. And now that even if the total valid votes, all the votes are added, Nana Addo Dankwa still received 6,730,413 total number of valid vote cast, and that of a percentage of 30,249,129 votes would have given him 50.798% votes cast. As to the alleged vote pardon and the wrong aggregation of votes, the Supreme Court dismissed those allegations with consummate ease. Indeed, if you added the votes that they themselves said were pardoned, in one instance it's 6,622, another instance is 5,562, and then when it mattered most, they initially started with 32 constituencies and it dwindled. They started with 32 constituencies and it dwindled to 26 constituencies, and the vote pardon came to 4,693. Now the courts were clear that these votes, even if taken out of second respondents' votes garnered, did not materially or substantially affect the validity of the election. The Supreme Court also said that the alleged vote pardon was not supported by any credible evidence, and you can't rely on infractions that affected votes at polling stations when the votes are validly cast. Administrative errors or mistakes by electoral officers can never and will never change the sovereign will of the voters who cast their votes at the election. And your lordships quoted a passage from Lord Denning to support that position of the law. Ladies and gentlemen of the press, in short and in brief, this is the thrust of the judgment of the highest court of our land. And your lordships posited that one cannot ignore the substantive truth of an election and resort to innocuous errors committed by first respondent's chairperson in the declaration of the results, and on that position, call for a rerun of the election. Your Lordships also stated that the petitioner was not able to bring one single piece of evidence to show that the allegation that none of them, that is the petitioner and the second respondent, crossed the 50 plus of the total valid number of valid vote casts to warrant a rerun of the election. The Lord Justices of the Supreme Court have spoken. We entreat all Ghanaians to abide by the decision of our highest court of the land. We thank our good friends on the other side for their bravery in mounting this petition, albeit we all found that the petition indeed contained nothing but factual errors and inaccuracies. Those were in the words of the court, not mine. Litigation must always come to an end. We want to believe that this is the end of the 2020 election petition. I'm fixated with 2013, so spare me. Ladies and gentlemen of the press, if there are any questions, we are prepared. I'll do them. If they don't, I'll do them. Yeah. If there are any questions, we will take them. I'll do that. That's why I said they should ask questions. If they don't,
I think you have no questions.
Do you have any questions?
Don't worry.
You don't. We'll do that. That being the case, Charlie, can someone fetch Sheshe? Sheshe is standing there. Sheshe is down. My friend. That being the case, on my own behalf, on behalf of the National Chairman of the NPP, the General Secretary, the Campaign Manager, the National Youth Organizer, the National Organizer, because the National Women's Organizer, she just left us, the Nasara Coordinator, the Campaign Manager, and our star witness, the redoubtable and irredoubtable Peter Menu. We want to thank all of you, ladies and gentlemen of the press. Of course, our Director of Election, we'll do that. Our Director of Election and adjunct lawyer, Ivan Simako, and I almost fell into trouble. The master tactician, the technical wizard, the little boy computer, Joe Anochi. We thank you all for the enormous assistance you have given for bringing this petition to the doorstep of the people of Ghana. and for the belief you people have had in the process. Yes, our justices are human beings, they are fallible. But when they decide on a matter, that obviously should bring that matter to an end. There are other means of challenging their verdict, that is, if the petitioner is want to do so. But we pray that Ghanaians should accept the rendition of the Supreme Court in the supreme interest of justice, so that governance of the country can continue in these challenging times of the economic rostrum